So there was an employee named Peggy Young who worked for UPS as a driver for many years, and then she got pregnant, and she had certain pregnancy-related challenges, and her OBGYN indicated that she couldn't lift heavy packages for the last 2 trimesters of her pregnancy. So she asked UPS for what's known as a reasonable accommodation that would allow her to get assistance from her colleagues if she had to lift a package that weighed more than 20 pounds. And because she was an air driver, so-called, meaning that the packages she delivered were typically the very light letters that are sent by overnight air, the chances that packages would be that heavy that she couldn't lift were few and far between, and she would have had assistance from her colleagues, and again, for a very short period of time. But UPS said, heck no, we're not going to accommodate you, even though UPS accommodated all kinds of employees that had all kinds of problems, such as injuries on the job, accommodated them with light duty positions, or people who had disabilities under the Americans with Disabilities Act. And how about this? UPS would accommodate drivers who lost their licenses due to drunk driving convictions. But it would not accommodate pregnant women that needed flexibility in order to continue working during their pregnancies. So Peggy Young couldn't continue working, and she ended up losing her health insurance and ultimately her job with UPS. So she sued UPS, and the United States Supreme Court, by the time it got all the way up to the highest court in the land, found for Peggy Young, saying that how could UPS get away with accommodating all kinds of groups of people that have all kinds of challenges, but then refuse to accommodate women who have pregnancy-related medical conditions. And so since then, it is now established law that if you're pregnant and you're dealing with gestational challenges that are a result of your pregnancy, an inability to lift heavy packages, or you need flexible time because of morning sickness or gestational diabetes or any issue related to pregnancy, your employer now must consider what your needs are and be flexible and reasonably accommodate those pregnancy-related challenges. So if this is the situation that you're in, make sure that you ask your employer, document to your employer that you're having pregnancy-related need for flexibility, and ask them for it, because now your employer can't just say, sorry, no. They must go through this analysis and determine if what you need rises to the level of an undue hardship on the business. If it doesn't, they're going to need to accommodate you and treat you the way they would anyone else with a disability that has nothing to do with being a pregnant female in the workplace.